state, and you now have a live numinate, is to order a live numinate or order a regular numinate with the SSA-711 form, and they should tell you that they can't provide that for you. It can only be a dead numinate or a live numinate.
How's it going, JW?
It's going great, man. How are you?
Doing good. I actually missed anything you said after I said about trying to get all the documents together, so I make sure I got my ducks in a row for probate.
Well, darn it! I thought you might have been listening. I was talking about how I was on a Zoom once with Boris and Jim about last August, and Jim kept saying, "Well, what does the name change do for you? You know, what's it really do?" I was like, "Well, I got a citation a week after I got the name change, and never had to go to court because the DA wouldn't prosecute me, and there was no docket number created. And then I got a letter back from that police department with my name in upper lower on that envelope that said, 'We had your person in custody for 26 days, but the district attorney declined to prosecute, and we had to notify the Department of Justice Bureau of Criminal Identification for the reason why.' I guess they have a Bureau of Criminal Identification, and I'm no longer using a criminal identification. And then it happened a year later. I got cited, no docket number created. I sat in jail for 3 days, got let out, no docket, no charges, no nothing in the computer."
Do you know the website that, or the group that they have a PMA and it's called myhouseshallbecalled.com?
No.
Yeah. Daniel is this guy's name. He called me yesterday after he watched my
House of Prayer, Daniel?
Yeah.
Yeah.
So you know him?
Oh, yeah.
Yeah, he called me yesterday. He told me he wants me to come on his show tomorrow night.
Good. Are you going to do it? Right on, yeah. He's a good guy.
And he actually likes my thought processes, and he says that I'm on target. And he said he was really impressed when I told the people, look, no one man knows all the law, and we all know bits and pieces. And if you don't have the right teachers, you're going to get misinformation.
Or do your own research, yeah.
Yeah. So I'm trying. I told Daniel yesterday, I said, my goal, and that's why I'm asking for certain documents from people, is I want to have my case ready to file in 3 months.
There's a call with a KL Mr. Beneficiary who knows about name changes. I just put in Fearless Woods group at Mega. That's with Daniel at House of Prayer last year sometime.
Well, I'm going to download that. But what I told him was, and I know some people don't agree with me, but in my opinion is this: I used to do construction, right? And you take that to the biblical principle when in the New Testament, when Jesus talked about your foundation, or if your house is on sand, you know what I'm saying? What is he talking about? He's talking about the foundation. And what I tell people is, honestly, I think you got to go back to the foundation. If the probate case is the foundation, everything comes off of that. That's just my opinion.
Well, in the Gospel of Thomas, they asked him, "What will the end be?" And he said, "Why are you worried about the end when you don't know the beginning?" You got to go back to the beginning to find the end. Yeah.
Yep. But he told me some interesting stuff. He told me about a guy that he knows that actually registered with the United Nations as an internationally protected person. And I said, "Oh, nice." and he got his passport under that classification. They don't mess with him.
After all these years, now wouldn't that be nice? Actually having some kind of a semblance of what you thought it was supposed to be like from high school civics classes, right?
That's right. And even though he told me that, I'm of the opinion until someone can prove me wrong, and it doesn't appear anybody can, that you got to start at the foundation, you come off of that, and everything else starts falling in place.
So what would the deed of acceptance look like? What kind of verbiage would you have in it?
A deed of acceptance and acknowledgement. A deed of acceptance and acknowledgement and reconveyance with consideration. There's a Harvard book I got linked to about doing deeds of acceptance, but it's just a paragraph or two. One paragraph.
I actually thought about going on the Westlaw in the forms section and see about finding a deed of acceptance, because the one thing I love about the forms, they always put them they make them in a short, concise way that is legal across the board.
Yeah, equity will not complete an imperfect gift, and just because it gave you a decree, until you accept and acknowledge it, it's not perfected. You got to say, hey, thank you. I accept this. That's all.
So it's a deed of acceptance and acknowledgement and reconveyance with consideration.
With consideration, because without consideration is a volunteer, and equity will not aid a volunteer.
Could you proclaim that your signature is consideration, since it is performance?
Well, yeah, and giving a name is also consideration, but a cancel stamp is definitely consideration.
Okay, so you can put a cancel stamp on the document.
You paid for the court docket too.
Anything of value is lawful consideration. The courts have never said how much the value has to be. It can be anything of value. That's why there is a court case that a peppercorn was given for lawful consideration to purchase a house.
Oh wow, a peppercorn. Okay, so pretty much, because I was looking at consideration, and it was saying that performance or anything of value pretty much constitutes as consideration. So I was thinking about just declaring a value of my signature and doing the cancel stamp for consideration.
Yeah. I mean, so once you understand anything of value, that's the reason Crazy Mark is what I call him. Mark up Minnesota, the court will not let him in the courtroom if he's got his bag of rice on his hip. Rice is a commodity. Rice has value. So guess what? It goes back to the whole coffee bean case. If you haven't heard of that, a guy discharged a debt using coffee beans per the order of the judge. The judge got trapped up in that one. So anything of value, that's why we have a huge commodities market. And look at what's all on the commodities market: sugar, salt, rice, coffee beans, food products, right? Or gold, silver, copper, things of tangible value. All they did in 33 was change the system to where you can't demand payment in gold and silver, and they changed it to where you can settle debts with things of value. So what did they do? They created this whole system of securities, promissory. There ain't but really two things: promissory notes or securities. Everything revolves around that. A promissory note is anything that has a maturity date of less than 9 months. A security is anything that has a maturity date greater than 9 months. That's according to the UCC. Now, under the definition of securities, there are many, many different things that are classified as securities. And it is a long list of things.
So once you do that acceptance, you're pretty much conveying the legal title back over to the state or the county.
Yeah. Render unto Caesar that which is Caesar's. Render unto God that which is God's. The birth certificate is Caesar's. So what do? That's why I'm of the opinion that Boris is right, and Sean Haggerty, Smoking Baby's right. You got to surrender the certificate back to Caesar, because the infant or the placenta was registered or recorded by the hospital. The baby was never recorded. So if the infant was abandoned, aka the placenta, and the hospital recorded that infant, and this is why I haven't found any evidence that clearly lays out that the certificate of live birth is a death certificate, even though I believe it just based on the principles. I would really love to find the evidence where they admit it, but it makes sense because why? The placenta was alive, and within a few hours after it was detached, it died. Don't know how many hours. I mean, it could be a day. Don't know. I doubt it's longer. I doubt it's that long. But the presumption of death comes in on the infant, and that was according to Harvard and a book that was written in 1909. So the infant, being the placenta, was left behind and recorded. But since it was abandoned, it becomes property of the state to do the trust and create these securities on behalf of the infant. And what do they do? You got to surrender back to Caesar what is Caesar's, so you can get what is God's. And that is what? You're a living man made in the image of God. They don't have jurisdiction over you unless you have an injury or harm to person or property where you actually violated another's rights.
So when you convey it back over to them, you want to give them like instructions on how to regulate this legal title for the benefit of the beneficiary. So
Not
you
the
would be like
original,
a grantor beneficiary.
not the original infant estate. I don't think you give them anything other than surrender the certificate. Why? They know what to do with that. My opinion is they collapse that trust, and what do? They settle all the debts of the infant.
So when you're accepting,
when you corrected the information, what JW was talking about, the name change, so you correct the birth record where you are with your given name, last name, all your measurements, everything, by recording your own birth certificate, okay? Then you take that, and then you can give that to the state to manage the trust, and that means they become the trustees. You become the creditor, because what is the last sentence of the Declaration of Independence? They pledged all their wealth. Now, if you do the same and you pledge all your wealth to the United States, doesn't that make you a creditor to the United States?
Yeah. And when you pledge it, would it be like a Bailey Baylor relationship to where they would be holding it for safekeeping purposes?
I don't really get into the Baylor Bailey, because at its root, what are you? A creditor or a debtor? That's all I care about. Am I the creditor? Am I the debtor? Because everything comes off of that. A taxpayer is a debtor. An obligor is a debtor. A bailor is a debtor. They all come off of the phrase, are you the creditor or are you the debtor?
So you're saying that a bailor would be considered a debtor?
I'd have to look it up, but yeah.
I thought the bailor was the one that would be giving the property to the bailee for the bailee to hold it for safekeeping purposes.
It may be. I'd have to look up the definitions, but most of your definitions that have the E and the or, the transferee is the one that transferred it to the transferor. Okay. The transferor becomes the taxable party. That means what? The taxable party is the debtor. See what I'm saying? An obligee is the one that is the creditor. The obligor is the one that has to fulfill the obligation. So, I mean, I'm just using the or and the E. The suffix is saying, okay, this is what it is. Now, when I go to Black's Law Dictionary and I look them up, I could be wrong. I haven't looked them up. Because to me, all that matters is which side of are you on, the creditor or the debtor? Because everything else in their definitions revolves around those two terms.
So what about the trust aspect? About
you've got the Social Security trust. It has to be funded. If you surrender, like JW was talking, you correct the record. They collapse the infant trust to settle the debts of the infant. They create a new trust in the new name, and you do what the last sentence of, you pledge it to the United States. Well, you made a pledge to do what? You're becoming the creditor, because you're giving your life, your estate, etc. Now, because the United States is in bankruptcy, Chapter 11, been in bankruptcy, Chapter 11 since 1933, they can't leave you destitute. That means what? They have to give you something to provide for your necessaries. This goes to the necessary and proper clause of the Constitution. And since you're now the creditor, they have an obligation to provide those necessaries. Could it be the avenue to the black card? Don't know, but I'm sure going to find out. By the way, Beth, you said the key phrase, correcting your status. most of the teachers out there have it wrong. And it's just based on my recent discoveries. I used to believe what they believed. The whole thing that they say, well, you're a U.S. citizen. No, you're not. The trust is the U.S. citizen. You are not the trust. And there's no records that I've seen, because I did a FOIA request. Dawn in the national group, she did the same FOIA request. And her document come back the same, saying there's no records on file that I am a U.S. citizen. So how can I correct something until I know what needs to be corrected? It's just like a lot of those teachers out there says you need to unpatriate yourself from the United States and repatriate yourself back into the state. Well, how can you undo something you never did?
Or last night they were talking about it again today, but they were talking about David Straight. Repudiation of citizenship. Okay. So you're going to write so that which is not excluded is included. So you said you're not a U.S. citizen. Did you say you're not a zebra? You would have to include every single thing you're not if you're going to start going that direction. Instead of just saying
I agree.
What you are, right?
Yeah, that's right.
But, hey, man, creditor and debtor, that's the tree of good and evil, man. The tree of life was connected to your navel where the living waters flow from. Nepomuceno looks like a doggone tree. Jesus wasn't on the left or the right. He was in the middle. Zero balance, man. 0 point energy. He wasn't a creditor. You didn't invent electricity. You can flick a light switch and complete a circuit and a light comes on. But, you just flick the switch. You didn't create electricity. You didn't create credit. And you're not underwriting all that credit. Your signature only allows the release of the credit.
Correct.
Right? Your name is the beneficiary. You are the heir. You can be
right.
an heir, and it's all trust law. There ain't no creditors and registered agents in trust law, man. There's trustees.
Now, I disagree with you on that.
I know you do. That's why I'm pounding on it again, because you still got secured party creditor residue mingled in with trust law. Pick one lane and go to it. Pick a lane and stay in it, man.
Hold on,
or don't teach it wrong. Don't run around teaching people I'm a creditor, secured party creditor in my trust, and I'm a registered agent, and I'm going to resign as a registered agent. Hey, go ahead and resign. You're still abandoning your trust until you claim it as the heir.
Hold on.
You can pledge. You can't surrender a birth certificate. You can only surrender the interest in the certificate as well.
Now let me
That's the beauty of having an assignment. Once it's assigned to you, the duties of an assignee or assigner is now, his assignee's duties are now, as an assigner, he's got 4 duties he can use: appointment, allotment, assignment, and apportionment. Okay? So yes, you can reassign now that you've got authority to reassign under the Assignment of Claims Act of 1940.
JW, it is not residue from the secured party creditor stuff when I say registered agent. It's from the laws of agency. Because
agent in principle is commerce. In trust, you have beneficiaries and trustees, man. You no longer use those other terms. A trustee is a trustee is a trustee is a trustee. You get an EIN with an SS4 for a living trust, a revocable trust. And you know what it's going to say? Whose the name is there for the EIN? It's a trustee. They don't call it a registered agent. There's the mailing address, and there's the name of the trustee. Nowhere on that EIN does it say registered frickin' agent.
You're not wrong, but hold on. Damn.
It's been weeks now, and you keep saying it. You're the registered agent. For a
Listen,
principal agency relationship, which is not a trust relationship.
Let me
Man.
finish. A registered agent is a default position, whether it's expressed or not. In principle, yes, you are right. For service of process, the trustee operates as the registered agent. Yeah, it has the name trustee. And that is the known. Now, hold on. Let me finish. I'm not done.
No, you got it backwards. The trustee is the trustee when a trust has been expressed. When that which is expressed extinguishes that which is implied. You were implied registered agent all this time, and that's what screwed you over your whole life. Now, if you want to express a trust, there's no longer agent and principal. It's trustee and beneficiary relationship, okay? Once the grantor does the grant, he's out of the picture unless you set up a living trust. Now you can be the grantor and the trustee and the beneficiary all at once.
Yes, but what you're missing is when I talked about the registered agent, I was talking about the Social Security account. Because that's the minor account. That's listed. And I'm not the trustee.
Yeah, when there's no trust expressed and you got a bunch of people running around civilly dead, running the name without permission, renting it gave it to the DMV, the birth certificate, in exchange for a name they could drive. A license to use that person to do that which is unlawful. So, that's the default position. But, hey.
Think for a second. When it comes to these Massachusetts trusts that the Rockefellers create, when you go look up their trusts online, and you can do this, they're registered with the SEC. Okay? When you go look up they always list a registered agent.
Just for service of process. They're not an agency. It's not agency principal relationships. It's just
all I've said is for service of process.
Yeah, it's not an agent.
I never said it was.
For a principal, it's just a place to send the mail.
That's right. And when
so they can get it to a trustee.
Correct. Yeah. That is all I've said.
Well, that's good. But it's very confusing to say, for newbies, for you to say that their trusts have four parties. Invariably, trusts have four parties: a grantor, a trustee, and a beneficiary, and a registered agent. No, it does not require a registered agent to set up a trust. Never has, never will. The trustee is the responsible party. If you want to call him a registered agent, he can set up successive trustees, okay?
When I did my LLC,
that's commerce. What's that got to do with anything to do with trusts?
That's right. Okay. Under the 14th Amendment, all fictions are legal persons. They cannot act without somebody filling an office. Okay? So the point I was getting at is, which office do you fill? Because the Social Security number is in commerce. Okay? And it is still a trust. So all trust law applies. You are not the trustee because the state tells you who the trustee is. That means what? You say you're the beneficiary of the trust. Where's your evidence that you're the beneficiary?
No, I don't.
You're not the grantor.
I don't.
You didn't create.
I don't ever say that, brother, because I'm not a name, and a name is what is the beneficiary. I am the heir.
I'm saying,
and it says so. It says that right on my name change petition. It says, "What is your relationship to the person, aka trust, whose name is to be changed from unassigned to now assigned to someone who showed up?" Well, what is the relationship? I wrote You want to know what I wrote? I wrote living heir to the infant decedent's legal estate. And the clerk stamped it.
Yes.
I didn't write that I am a beneficiary.
That's right. But not only, but
And
it's
if I
not
had
about,
son,
I'm not talking about what you did and you completed. Most of the people on these calls want to know how to fix things and what to do. And what do? One, you got to teach them who they are at the time they are at and how to navigate from that point.
there's somebody who's using a name that's been abandoned since they were age 7, so they're civilly dead. That's who they are.
Yes, that is
They're
right. That is who they are. But what office are they filling?
several.
They're
Executive
never
de
the
son tort,
trustee.
trustee de son tort, registered agent de son tort.
Well, they're
Surety,
not they're not the trustee. That's one of
surety
the
in
things.
error. No, well,
That's
really, if you show up in court when they send something to that name and you're not acting as a trustee because you didn't go find the responsible party, the indispensable party, the United States, under Rule 19, so aren't you acting as a trustee? Yes, you are, and you're paying the
no,
bill for the estate. Look, if you're paying the bills of the estate, then you are acting as the trustee. Doesn't mean you are the trustee, but you're acting like it, so they're going to treat you like it. You can go to jail just like the trustee.
now, well, this is why I disagree with you on that. And it's because of the legal definition of trustee and trustee de son tort. The legal principle behind trustee de son tort is not that you are the trustee. You were operating in a position, in layman's terms, that you don't have permission to operate in, and that's why you are liable.
No. How can
Yes.
you? How, you're operating in a position which you're not responsible for. Is
Well,
that
let's
is that? Wait. I'm just trying to break that down. So
okay,
you're
let me
operating.
read the definition.
Okay.
Okay. Trustee de son tort. Okay. Someone without legal authority administering a living person's property to the detriment of the property owner. See constructive trust or constructive trustee. A trustee de son tort can be made a constructive trustee, but they're not the trustee.
Well, if they can be made and they're not, then I just get this, like, you're in the courtroom and the judge is like, hey, guess what I made you? Now pay, right?
Yeah,
So
that's right. Now,
and if the judge, hold on, if the judge is acting as the the boss, the principal, the executor, the administrator, or whatever, right? Then wouldn't he have a responsibility to know who the trustee was that comes forward? So if he knows who the trustee is in that party, and a person comes forward and says, yeah, I'm that person, and he knows the difference between a living heir and a fiction, well, obviously he knows, because if that's why some people walk and some people pay, because it's not because the judge knows, it's because the person, the living heir, knows what role they're playing. I'm getting confused now. But if they know
well,
what role they're playing, all
hold
right.
on. Let me share this.
I'm just saying, if the judge knows,
The
then
judge definitely they know.
then
Yes.
the judge should be at fault for abusing a trust.
Now, no, because if you read this citation, I just shared it. It's underneath the link, cage.dla.mil. I just copied and pasted the whole thing. It says, and this come from Moore v. Crawford, 130 U.S.122. This Supreme Court case. A constructive trust is the formula through which the conscience of equity finds expression. When property has been acquired in such circumstances that the holder of the legal title may not in good conscience retain the beneficial interest, equity converts him into a trustee. What they don't tell you is what type of trustee. So now, the reason I brought up trustee de Santort is if you go look up SSA Board of Trustees, they tell you who the trustees are. Now, a trustee de Santort is one who does not have permission to administer the property. Well, if you don't have permission to administer the property, that's why they use de Santort. In other words, you're trespassing. So when I did this on my traffic ticket to test the theory, it worked. If I'm not the trustee, then what am I? Not the grantor. I have no evidence that I'm the beneficiary. That means the only office I can hold is what's considered the registered agent, the one that handles service of process. Now, the registered agent has a fiduciary duty, and that's to notify the principal. And if I don't do that, then I can be held liable. And that's where trustee de Santort comes in. Because I'm trying to act as the trustee, and I'm not. I mean, Popeye out in California, when they tried to get him to express the name, he told the court, he said, I am of the opinion that name is property of the United States, and for me to unlawfully use it would be fraud upon the court. And the judge said, what should we do about that, sir? He said, you can call me Peaceful Inhabitant. He said, okay, Mr. Peaceful Inhabitant. And Popeye,
no, I've heard the story, Pastor, but
yeah,
I get really confused when, somebody walks into court, right?
mm-hmm.
And they, so if the living heir doesn't walk into court, what happens? When the living heir walks into court, what happens? And it seems like they're going to get screwed. That's what happens. So
yeah, if the
you're
living
saying
heir,
you're saying, no, this is what you're saying. You're saying that the living heir has no right, no business to call himself the trustee, right? Was that what you're saying? The living heir has no right, no business to call himself the trustee?
Not until he fixes his situation to where he takes over the estate.
Okay, so he doesn't fix it, okay?
Lack of better terms, I'm just using common.
Yeah, no, I get it. No, but if
JW fixed, he did the proper part to where he took over the infant estate. But right. What I'm talking about is where is the average person at? They don't understand the principles of where they're at right now.
Right here, Pastor, the average person. No, but so let's get back to the average person that hasn't gone, the full process, hasn't established, still a 14th Amendment, whatever, walking into court, right? So the legal fiction gets summoned, right? And
that's
right. They present themselves as a special appearance, right?
Well, what if they don't? Because the average person
let's say they don't. Look, to me, it doesn't matter what they do, because it's like a no-win situation for them.
Actually,
right? Because they're not supposed to go in there and act as the trustee.
That's
so you can't walk up to the judge and be like, hey, I'm the trustee, right? Because you're not.
That's right.
So How do you handle that? Would you be like, I didn't show up for the summons because I'm not the trustee?
What I did in the traffic ticket was
and then they come kicking down your doors.
No,
So what do you do?
When I went over that traffic ticket, they asked me, was I the name? And I said, and I never showed my face in court when I did it. I did it over the phone talking to the court clerk. She asked, was I the name? I said, ma'am, that name is owned by the United States. They are the secured party in this matter, and I am merely the registered agent, and I must notify the principal of anything that affects its interest. And they sealed and dismissed the case. Every one of these court cases, they are creating a constructive trust.
So with your police, that traffic ticket or whatever,
yeah,
were you average?
Was I average? I haven't got my estate in control, so I'm saying I'm a little above average.
Okay.
But I know which office I'm operating in now.
Well, thanks to you, I have no clue. You just blew me out of the water with what office I would operate under. Because obviously I can't be the trustee because it's an infant child estate.
It was and it's property of the state. They admitted that to me on the phone call that I played on the video I did almost 4 weeks ago.
No, I know that I don't own the SESTA account, the social security number, the all caps name. None of that's mine.
So only the trustee can manage it, right?
Well, who is the trustee when you're average? When the estate is the child? Or
when you said who is the trustees?
Yeah, who is the trustee?
They tell you who the trustees are.
All right, so on a traffic ticket, who's the trustee?
It's not the point of on the traffic ticket. They put it in the name.
Isn't that you're like making up a trust when they write the traffic ticket? Aren't somebody expressing a trust when you say like, here, sign this? Is that not the moment an invocation of a trust happens?
No. What they're doing is leaning the estate. Okay? They're placing a lien against the estate.
Right.
And we're talking about the Social Security Trust.
Yeah, traffic ticket.
Now, a lot of people you hear people say, they stole my name, they're accessing the account. No, they're not. So, they're placing liens against it. Okay?
So all right, I'm average, Pastor. I get stuck on things, and you do a great job of trying to set the path clear for me. Mm-hmm. But when that cop says, "Here, sign this," right?
Yeah.
And there's like 50 million things you can do at that moment, but at that moment, you're saying that you're just being presented a contract and not a trust?
No, that is service of process. It is a legal document. Okay.
So is that a negotiable instrument at that point?
Oh, it's a debt instrument for sure. That's what I told the clerk.
Okay, so if it's a debt instrument,
yeah,
just stick with the fact of the debt instrument. Is that a trust?
I did that.
Yeah, is that a trust? The debt instrument itself?
The debt instrument itself may be, may not be.
Okay. So, wait. I know I don't want to seem like I'm pushy and I'm not listening, but I'm just trying to, the reason I asked whether or not the ticket was a contract, and then I asked whether or not it's a debt instrument, is because I want to ask, well, then what's the birth certificate? Is that a debt instrument?
Why didn't you just come right out and ask it?
Because I didn't want to, I want to have like linear thinking of one specific situation and then use comparisons of others to make an association of what exactly is that traffic ticket. Because you said it wasn't a trust, And I'm there like, wait a minute.
The
If that's an
document
instrument
itself
and a birth
isn't.
certificate is an instrument, then I guess a birth certificate's not a trust?
No, it's not what I'm
Okay.
saying.
So this is where I'm falling down on
An instrument
exactly.
itself doesn't express a trust.
Okay.
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 You're saying the ticket, did it create a trust? The ticket itself didn't.
Okay. So the ticket itself is not a trust.
Of its in and of itself, no.
How does it become a trust?
That's where the DA goes in and creates a constructive trust in court.
So when the DA creates that constructive trust in court,
they are the trustees. They want you to fall on the sword and take their place.
So they want you to act as the trustee, even though they're the trustee.
Under trustee de Santort.
Right.
Yes. Now, the birth certificate is a few different things. Okay.
Well,
one,
we can
it
just
is
stick
a
with the
trust
ticket.
certificate.
I was just using that to clear up what a ticket was. I don't want to like go
It's a
off
negotiable instrument on its face.
Okay. So the trustee wants to make somebody else the desantor to become responsible to settle the matter. Is that right? They created a matter. You know, the trustee has created a matter, and now they're looking for somebody to take that responsibility away from them as a desantor. Is that how they're doing it?
Because they don't want to hold the liability.
Right. They want to shift the burden of responsibility from their fiduciary responsibilities to the desantor.
Yeah.
So they can take a chair and get paid.
Yeah. Right. Obviously.
If you go watch the video, Bankruptcy and Revised Article 9, Part 1, go to the 8-minute mark. Okay? The gray-haired dude, I don't know his name off the top of my head, they tell you what they're doing in the courtrooms with these instruments.
Well,
he says something along the lines of, yeah, can they securitize it, monetize it? And everybody giggles. He says, well, I don't know where this is going to go, with a big old grin on his face. And all they talk about in this video is being able to take the property away from the trustee. The problem is, if you're not the trustee, because you have no evidence you are the trustee, then who are they actually taking it from?
Is that a true statement when you said they are taking the property away from the trustee?
Yes, because everything in this country...
I'm not the trustee. So how can they take something away from me?
Because you volunteer to accept the role they place you in, because they're not telling you that. Yes.
So how come nobody's running around? How come nobody's running around
when I had a
expressing
7-year
that
battle
point?
with family court? Why do you think I did in the traffic ticket? Because I've come to this realization. See, I had a 7-year court battle with family court. Okay. Near the end of the case, what did I do? I did the GSA bond process. Things went really weird. The 5th court-appointed attorney that I had filed papers to get removed from the case. One of the things he admitted was, by me doing what I did, was I was interfering with his fiduciary duty to manage the accounts. Okay, wait a minute. Now, if you file a bankruptcy case in bankruptcy court, there's two attorneys there. Okay, one for you and one for the state or for the supposed creditors, right? What do they call themselves in court? Trustees. Why? Because of the Social Security trust account. If you look at the Board of Trustees, this is my presumption. There are 2 spots out of 8 that are always left blank. It is called a vacant public trustee. So the attorney comes in and fills the spot and is managing the account. The judge knows this. They're leaning the estate so they can create securities and and monetize those securities on the municipal bond market. But they need you to play the part of the dummy. Because when I talked to this guy, this attorney, after the case was over with, and I asked him certain questions, and he said, what? I can't discuss that with you because of attorney-client privileged. Wait a minute. Wasn't he on paper my attorney? No. He was the attorney for the infant estate. You're just playing the part of the dummy.
So how come the gurus ain't expressing that? They say go in there and make a special appearance, and how come they're not yapping about desantor? Be like, Your Honor, why is he asking me to be a desantor?
Because there's
a child infant estate going on here. I have no control over it. I'm just here to let you know that. So
the reason they're not doing it is because there's a lot of bad teachings out there. Look at Anna von Reitz. Look how many followers Anna von Reitz has. Anna von Reitz is one of those that says, do special appearance. David Straight, look how many followers he got. Between the two of them, they have hundreds of thousands of followers. They are basically, for a lack of a better term, they appear to be the top of the pyramid in the legal community, and I personally believe they're agents. That's the reason they have so many followers. And now look, how many gurus are out there? They're a dime a dozen. And what does almost all of them push? Templates. I got a template to fix any problem you got. Do this template. And the people don't even know the principles behind it. They don't sit and read. JW, he's probably spent more hours reading because he's been, JW, have you been at this longer than 10 years?
Well, the old school stuff that everything was wrong. I used to study 20 years ago, but no, renewed studies began in 2015.
Okay. I've been at this 10 years. I've learned more in the last 8 months than I've learned in the last 10 years. Because once I got past the secured party creditor stuff, because what is the number one thing they teach you in secured party creditor? To establish a trust.
UCC 1.
No. Put your birth estate into a trust. Everything else revolves around that trust. The UCC 1 filing, the private bond, sending the copy of the birth certificate accepted for value, all of that revolves around that trust. So they teach trust law. But what is the biggest trust nobody talks about that is in front of everybody's face? The Social Security trust. Guess what? The
You
same
asking
trust.
rhetorical questions. I wanted to answer that.
Yes. Yes. It is a rhetorical question. Yes. Because why? It's the
I
number
was
one.
chomping at the bit.
Okay, go ahead. Give your answer.
You got me good. I was going to say the SSK.
Well, so the Social Security Trust is a trust. That means the principles of trust still apply. Now look at that definition I shared. This is from Black's Law Dictionary. Both definitions, you need to pay attention to them. The word dummy, a party who has no interest in a transaction but participates to help achieve a legal goal. So you come into the case as respondent, defendant. You can't talk, but you're participating so the court can make money. But look at the next definition. A party who purchases property and holds legal title for another. That's the infant estate. If the state owns the property, the infant estate, they took the infant estate to the federal government and said, hey, we need a bank account. Okay, what does a bank do when you create a trust? The bank says, we need to see your trust certificate. So what do? They issue a trust certificate. You call it a certificate of live birth. I mean, Yusuf Ale, he teaches secured party creditor, but he says the same thing. That certificate of live birth is a trust certificate. It is your one beneficial interest in the trust. He's not wrong, but you don't know how you operate in that. People make the presumption that because you have the social, because you have this, you're the U.S. citizen. Well, I used to believe that until last 8 months, and I got to asking the right questions. If I'm going to make the claim that I am a U.S. citizen, where is my evidence that I'm a U.S. citizen? Social Security card isn't the evidence. It's a piece of paper. It is not a man or a woman. That's why I did a FOIA request. I'm not done doing FOIA requests either. But I did a FOIA request with the U.S. Citizenship and Immigration Office and asked for any records to show that I was a U.S. citizen. They come back and said there's no responsive records. So guess what I have now? I have evidence that I'm not a U.S. citizen. So how can I do the patriation stuff some of these teachers are teaching if I never patriated into it to begin with? And every legal fiction has someone operating as, in principle, a registered agent for service of process, because the legal fiction can do nothing unless someone operates the office. Yeah, the trustee. Yeah, well, we know who the trustees are. They're on the Social Security Administration website. That means there's other offices that apply. Do I have a problem being a registered agent? No. But slavery is illegal. If you want me to continue as registered agent, you need to pay me a salary. That's the way I look at things. And if I am the registered agent for this legal entity, because when you go down and you do a driver's license, what do they want to see? They want to see the birth certificate. They want to see two things, two forms of identification. They want to see the birth certificate and typically the social security number, right? Why do they want to see that? This is where I agree that KW is right. They need to know the name of the registered organization, and they need to know who the registered agent is. And what do? You give them your address, so that way they know who the registered, where to serve all the papers. See, a trust can appoint a registered agent. The big companies are owned by trusts, and they do it all the time. And I don't know about JW, but I know some people that have resigned as registered agents. Did they see things?
Does that when they resign as registered agent, are they abandoning that?
My theory is yes. That's why I'm not ready to resign. I would rather go to the court and basically lay out the facts, declare who I am, send the state a bill for back pay, because why? They never disclosed this. They never said this is what you're doing. So that means I was at a disadvantage of being able to do my fiduciary duty on what I needed to do by law to be able to settle the debt of the estate that I am part of. So guess what? Since slavery is illegal according to the Northwest Ordinance, you owe me back pay. Because why? If the state doesn't think they owe me back pay, then that means the state by admission is saying, no, we don't owe you nothing. You're a slave.
Well, can't that position work the other way? I mean that they giving you no disclosure. I mean, shouldn't it be able to work where you give them no disclosure? I mean, for that, like, I don't know exactly what the equity or the maximum or anything, but the only reason that they can do something is because you can do the opposite.
Yeah, you're talking. I don't know the exact term. JW may know it. Equity doesn't support a volunteer or something like that.
No, well, I mean, like, the law says that we have to hang you. Well, isn't there something in the law that says, no, you don't have to hang me? And if there isn't something in the law that says we don't have to hang you, then if there is not something in the law that says, no, we don't have to hang you, then you cannot have a law saying we have to hang you. I mean, that's what I mean. Like, if there's a way, then there's a way out, right? Like, they can't make laws, right? Like remedies and reliefs. You can't, that's what it is. Remedies and reliefs. If there's no relief or remedy, then you can't do it, right?
They can never pass a law without leaving you a remedy.
And it's on that fact that, well, they did something with absolutely no disclosure. Well,
if there is no
then there must be a way that you could. There must be a way for you to do the same exact thing. That's what my train of thought is on.
No.
Remedy and relief, because there has to be a way that they could, create this cess decay without any disclosure. Has to be.
No.
Or they couldn't do it, right?
Actually, no. They actually do disclose everything on the trust. They disclose everything they're doing. The problem is you got to understand how the pieces fit together. Because why? They publish everything. They publish the congressional records for people that want to read. The congressional records tells you the intent of Congress. When they passed such and such law, what was their intent? Well, guess what? Nobody does. They don't go listen. They don't go
How are you
read.
going to read? And it's a question. How do you read the congressional record about the Sesta account, the trust that was created over in London? How's that on is that on the congressional record?
The Sesta Trust, the Sesta v. Act that was passed in London, based on my research, the principles of trust do apply. The Sesta v. Act does not specifically apply.
Yeah, but I mean, wouldn't that's where you find the disclosure in the Sesta Act, right? That's what I'm thinking.
No,
because of the Black Plague and then a fire, and now, hey, guess we got to do this. You're lost at sea. Have a nice day.
You're not lost at sea.
So,
see, hold on. Let me clarify something. The teaching among the community about the maritime law, you're lost at sea, they brought the sea onto the land, that's all wrong. See, the first thing people need to study is the Constitution. They publish a book called the United States Constitution with Analysis and Interpretation. It's 2,800 pages. Guess what? The average person never reads it. That's the most powerful thing you can read, to know how this system applies to you, if it does. Now, the reason I bring that up...
You're saying that right now, today, U.S. citizens are living under the United States Constitution?
I'm saying you have a book that is published for you to study because they are beholden to it. And they tell you if and how it applies to you. But nobody reads it. Have I read it in full? No. Have I read it in part? Yes. Do you technically have to read the entire thing? That's your choice.
Let's go back to the non-disclosure and the relief and remedy of that.
Well, hold on. Well, let me finish on the maritime law thing. In the Constitution, there's a phrase called admiralty jurisdiction and maritime law. Okay? But there's also another phrase called admiralty law. You don't hear anybody much discuss. I found it in Westlaw, and they are quoting Founding Father material. Okay? That admiralty jurisdiction and maritime law is a subset of the law of nations under the law of commerce. Now, so the way I explain admiralty jurisdiction is this way. You got a pyramid. The tip of the pyramid is admiralty jurisdiction. That's the power of the court. On the right side, coming down the pyramid, you got maritime law. On the left side, you got admiralty law. And what people are misapplying is both sides are contracts that are in commerce, one on the land, one on the sea. You're not on the sea, you're on the land, and it's commerce between the states. It's under admiralty law. It's not law of the sea.
So regardless of what side of that pyramid you're coming down, when it comes to the Cestui Que Trust, right? Because is there a situation where, oh, I was on maritime law, so the Cestui Que Trust doesn't apply to me because it's maritime law?
Where's your evidence that the Cestui Que V Act of London applies to you at all? That's another
where's the evidence
teaching
that
in
it
the
applies to
community.
me?
Yeah,
wouldn't that evidence be on the birth certificate?
No. I
Then
just
why
told
would
you
they?
a minute ago on
I
my
know.
studies in Westlaw. Westlaw is their documents that the principles of trust apply. The Cestui Que V Act does not.
So how do they get special exclusionaries?
Because everything, the Declaration of Independence, the Constitution, and Bill of Rights is a trust document. And guess who the trustees are?
The people living
No.
here. Yes. No. Yes.
No.
How do they fund that trust? Can't have a trust unless you fund it, right?
You're misapplying. I specifically said the Declaration of Independence, Constitution, and Bill of Rights is a trust document. When it comes to that document alone, who is the trustees? You said we the people. No. Because you're thinking we the people are all us. No. We the people are the trustees, but it's not us. It's Congress. It's the judges. It's the president, the vice president. Those government agents are the trustees for that trust.
Oh, yep. Yes, that's correct.
Okay.
I think. But who's the grantor of that trust?
The states, our representatives.
And who's the beneficiary?
And women in the Declaration were the grantors, and they're men and women.
Who's the beneficiary of that trust?
Well,
it should be the United States Treasury if you're smart.
Yes, that's right.
And future generations. Mm-hmm.
Yeah.
Otherwise, you're like Job.
We the people in the federal Constitution, the phrase "we the people" doesn't apply to us.
We the people who took the oath, be public trustees.
No, we the people doesn't apply to us, the citizens of the states. That's Barron versus City.
Well, half the citizens in your state did take an oath to run a public office. They're police officers, they're judges, they're all those things, and they lost their nationality when they took that oath.
That's different. That's different. Okay.
They're public trustees.
Yes, they are, but you're ahead of me here, JW. Okay.
Yeah.
Barron versus City of Baltimore. The judge in that case, a guy sues the City of Baltimore for seizing his property without just compensation under the Fifth Amendment. The judge in that case goes on a teaching rant. The basic summary is this. Sorry, sir, dismissing the case because it don't apply to you. Why does it not apply to you? Because we, the citizens of the state, we the people on the state constitution are the state citizens. We delegated a certain amount of authority, not all authority, just a certain amount, to our representatives. Our representatives is party one. They created a federal constitution to create a federal government. The second party to that document is the federal government. That is the trustees. The states are the beneficiaries and the treasury, because the treasury is to make money. So the government is profitable and can pay its bills. Okay.
So who funded that to create that trust?
Now,
who funded it?
At different times, it was different things. In
the
Constitution,
the very first time on that creation, okay.
In the Constitution, they tell you how it was funded. Taxes. What did they say? Duties, impost, and excise taxes. Now, what did Trump try to do? Try to bring in tariffs, which is a form of duties.
Right.
And what did everybody raise hell about? Because he was raising the tariffs on China, right? Well, guess what funded this country on an average 10% growth annually every year until 1913?
Well, when you say what funded this company, wait, hold on. When you say what funded this country, my mind automatically goes to a little piece of paper that sits in a filing cabinet. So it's really hard for me to like wrap my head around something that's dead. So when I ask who funded the Declaration of Independence or the Constitution, and you said taxes, but who funded the Declaration of Independence? Was it we pledge our lives and fortunes? Were those, is that how it got funded?
The founding fathers, yes.
Okay, so the founding fathers, were they legal fictions or were they living heirs?
They were living heirs, but you were not one of those.
I know that. So a living heir, right? Funded created the Declaration of Independence, but the Constitution was funded by duties and stamps and taxes, right? So
the government was, yes.
And the government's a legal fiction, right?
So
we have two documents, a Constitution and a Declaration of Independence, and one is dead and the other one's funded by living heirs. How are they the same?
No, they're. What are the basics of a trust? You have a declaration. You declare the trust. Then you have an indenture that sets the rules the trustees have to follow. Right?
And then you get the ball.
And then you have rules for the beneficiaries, right?
Uh-huh.
That trust document is one document. You have a declaration that creates the trust. You have the Constitution that sets the rules the trustees have to follow. Then you have the rules for that we call the Bill of Rights. These are the protected rights of the beneficiaries.
So you're saying that the Constitution, the Bill of Rights, and the Declaration of Independence is one entity?
Document. Yes. If you go create a trust right now,
if it's one entity, then there's one thing that funded it, that created it. So if there's one thing that created this entity, which one was it? Was it the duty tax stamps, or was it pledging of the fortunes? I'm trying to put it all together to make it one unit. And if one document, like the Declaration of Independence, is like, oh, the grantor is the fortunes that they pledge, and then you go to the Constitution and be like, the grantor is the taxes and duties. Well, how do they become as one entity? Would help, I guess. You know, like on one hand, we have our founding fathers pledging their lives and fortunes, and on the other hand, we have dead fictions, you know, producing excise, taxes, stamps. And you're saying it's one document. And crap, we lost. Oh, he's back. He's back.
Okay, the grantor is the person that created the trust. Who was the states that our representatives were the grantor?
So if our representatives were the grantors, then our representatives are legal fictions because they took an oath of office, right?
Every single one of those people that signed that document were what?
I thought, well, that document being the Declaration of Independence or the Constitution, I thought those signatures were from living heirs, real people.
Do those living heirs have offices they effectuate?
They do. They wear hats, the saying that they're dead, legal fictions.
That's
correct?
Right.
So, which one is it?
If the federal Constitution doesn't apply to you as a state citizen, and it only applies between the parties that created the contract, how is that hard to understand? What is a trust? A trust is nothing more than a contract between the parties. And if you are not we the people of the federal Constitution, then why is it hard to grasp that you're not yet a living heir?
That's a really good question. That's what I've been trying to figure out. And I get little bits and pieces of it, Pastor. And I always kind of go back to the idea that we don't have a constitution.
No, you do.
We don't
absolutely do.
Wait, let me finish when I say we don't have a constitution. The we
Okay.
would be the living heirs, okay? Because something happened and we no longer, or they, the ones that took the oath, the legal fictions that wear those hats, said, hey, we're in martial law now. And it's been like that ever since Lincoln. So the legal fictions have taken that Constitution away from the U.S. citizens.
No, they didn't.
Is my understanding.
Wait a minute. No, they didn't.
So we're not in martial law? Or the U.S. citizen is not ruled under martial law?
Yes, we're under martial rule since Lincoln, the Lieber Code.
Okay, so if we're under martial law, then we're not
take away
operating.
The Constitution.
I know they didn't take it away, but we're no longer applied to that. Well, the U.S. citizen is no longer applied to that document. I think they're applied to the Lieber Code.
You're still thinking you're a U.S. citizen.
I know. I keep saying a U.S. citizen would believe that they have a constitution, and the reality is that they don't have a constitution.
Go to the Governmental Styles Manual, 2016, page 109 of the PDF, page 95 of the book, and it says nationalities. What state are you in?
Florida.
You're a Floridian. A Floridian is not a U.S. citizen.
Oh.
A Floridian is a citizen of the state of Florida. See, people have forgotten what states are. States are 50 sovereign countries. We can debate Alaska another time because their constitution.
No, I have a question for JW. Mm-hmm. If I'm a Floridian, am I violating one of the 10 Commandments?
No. How is that?
Thou shalt have no other.
A Floridian is just your nationality, the country of birth, your birthright. That's the same thing of saying in your Israel back in the day.
My person's nationality. I'm a citizen.
Okay.
My person, my state person might have allegiance to Florida.
Okay.
Doesn't mean I'm a Florida citizen. My person might be, though.
Okay. I always get confused on what, legal fiction or living air. So thank you.
Yeah.
That cleared it up.
Well, I mean,
the air speaks. He moves air with his vocal cords. That's an air.
Take it back to Israel of the Bible. They were born in Israel, so their nationality was what? They were an Israeli. Does that mean they were violating the 10 Commandments? No. They were born in Israel.
No. Back then they were called Israelites. Now they call themselves
Israelites. Yes.
Because they're not real Israelites.
Yes, they were called Israelites. You're right. Okay.
Wait, can I butt in here for just a second? I thought that the term Israel came because he changed his name to Israel, and that's how they became the Israelites.
Yes, but that was when God gave a new name, and that's the principle we were talking about earlier on dealing with the probate court, is getting the record corrected to your new name. And it could be your given name and family name in its proper writing, or it can be a whole new name altogether, whatever you decide. Okay. So that's part of the principle, is God changed Jacob to Israel, gave him a new name, but Israel had children. Those children became the nation of Israel. Okay.
Right. No, I understand that. I was saying that they weren't born in Israel, that the name Israelite came from Jacob, right? That's my understanding when I read it.
No, they didn't start using the name Israelite till they developed their nation first.
And that's kind of symbology to show everybody where nations come from. Comes from people, comes from a family.
So the presumption of being a U.S. citizen is part of the problem. But look how we've been brainwashed to think that way. Back in the 1950s, they started pushing the Pledge of Allegiance, maybe a little bit before that. And they got you to start thinking of yourself as one nation under God, instead of 50 nations united under God. See the difference?
Yeah. It should.
So
can we go back to that not being disclosed?
Hold on, y'all stepped on each other. What was that, Javis?
Oh, I was just saying that whenever they use the terminology of one nation, combining all the states into one nation, that's more of a jurisdictionary term for jurisdictionary purposes.
Yeah, it is, but that's where you get into the Buck Act. The Buck Act created a federal overlay. It didn't do away with the Republic. The Republic is still there. That's why a lot of those people, when Trump took office and Trump got in office, they were this hogwash they were talking about. Trump dissolved the corporation. He brought back the Republic. The Republic never left. It's always been there. The problem is the people don't realize how they built an overlay like the Buck Act, and they created the zip codes for the federal zones to where they would have jurisdiction if you volunteer to be in it. And it's all about how you do it, the language you use, how you write things, everything. It's just like back in the day. They told you not to use the Social Security card as identification. Guess what they don't do now? They don't have that printed on there. I think they tried to warn us. Guess what? We didn't listen. The people in mass started using it for identification, and the government said, okay, just like God. God says, okay, I told you not to do something. You're going to do it anyway. So guess what? You're going to learn the hard way. The government said, okay, y'all want to continue using it for identification? We will give you what you want. And then we get mad at the government for giving us what we want. Well, I didn't want to go to jail. I didn't want to pay taxes. I didn't want to do this. Well, learn the rules so you don't have to.
You know what else I see a lot of bastards? People say they didn't give me full disclosure, and I was a registered agent, so I want to get paid. I'm owed something, rather than saying, blessed are the peacemakers, and let all debts be forgiven, and forgive my debtors so that my debts will be forgiven. And
exactly.
Just go forward from this day with your daily bread being taken care of, and not worry about getting paid for all those years as a registered agent and suing them for it.
Well, that's part of my process.
If you don't want to forgive them, why in the hell should they forgive you?
Correct. Now, just because I haven't stated that doesn't mean it's not going to be in my stuff. I haven't got everything written out yet.
After all the study, that looks like the smartest move right there. I forgive you, but give us this day our daily bread, and forgive our debts and forgive our debtors.
I'm actually looking at taking the Lord's Prayer, because you see all the comments, right? I mean, all the commas. You break it up in sections and make each part of my brief fit under each section of the Lord's Prayer. And when it says the part where, as I forgive those that trespass against me, lay out the facts of where the state trespassed against me. That includes the back pay because of the lack of disclosure.
I don't know, man. People say lack of disclosure, but they mailed a trust certificate to your house. And whoever called up Vital and said, what is this for? Or whoever called this county registrar who received it on the receipt date and said, what is this for and what do I do with it? None of us. But they prefer to say that they didn't get disclosure. You got a security in the mailbox. What more disclosure do you need? My Lord. You could call it a pledge. It's a pledge. In the mail. Mailed to her mom, tell them to send it.
Well, I understand, but that disclosure, that disclosure only disclosed that it's a trust, because why? They tell you it's a trust. right? But they, just like you argued with me over the registered agent, how many people understand the principles of the law of agency and what applies when it comes to that? See, the laws of agency doesn't necessarily just apply because you're a registered agent. The laws of agency apply in many different areas depending on the type of agent.
But it's never been a necessary element of a trust. It's grantor, trustee,
it's not.
and beneficiary.
Yeah, it's not a necessary element. That's correct. Just like when I created my LLC years ago, what did it put on me? They listed me as the registered agent by default. Why? Because I didn't appoint a registered agent.
And because it wasn't a trust, so you weren't called a trustee. And it's not a trust until the trust is expressed. Yes. And it's not for everybody. And so we don't need to be getting mad about it. You know, people that read the Bible and they realize that this was all set up so that you could have who's the grantor? 2022 years ago was the grantor. You know.
Well, actually, farther back than that, because God is the ultimate grantor. God owns it all.
And gave it all to who? And who got put on the cross. And so he was the grantee absolute. Yep. And then he set up a New Testament. And if you do his will, you can have what he promises through his will. In other words, the New Testament, so it's the will of the testator.
David said something really great yesterday. He said he carries a New Testament pocket Bible.
Who's David?
My House of Prayer. No, Daniel.
Oh, yeah,
my fault.
Daniel.
Yeah, Daniel. He said he carries a New Testament pocket Bible, right? And he says on the front page, "This is my last will and testament."
Yeah, I found an old book that says if your last will and testament does not include the Lord's Prayer, it is a defective will.
Well, not just that, but he says, you know, you've heard when you go through the probate, you got to create a last will and testament, right? You got to do that too. So guess what? He says he took the New Testament, said when the clerk, told him,
that's a deed of acceptance and acknowledgement. He perfected the gift of the New Testament, the will of his Father.
That's right.
And now
here's the terms.
He doesn't have an earthly father, whether government or his father, whose DNA was not in the placenta, that immaculate conception. He doesn't have an earthly father anymore. He's got a heavenly father. And what's your evidence that you have direct lineage from the living God? Well, because your heart is beating. That's your evidence. And your blood is alive.
Yeah.
But if you're born in the Spirit, you would express all that, and really mean it. And then, the vast majority of people are probably never gonna be there. And so for them, they don't even feel gypped. They want somebody to run their affairs. They don't feel gypped at all.
Well, you also look at this. The average person out there in this area, what is the number one thing they constantly talk about? I need a template to fix they say I need a template to fix my situation.
My status.
Yeah. Well, it could be status, it could be court case, it could be a ticket, it could be anything. Or the other thing you primarily see people out there doing is, how do I discharge all my debt? Like everything's supposed to be free. It's not. Okay. And I said, in the average person that's pushing all that, they won't go read the government's documents. They don't care to know how the rules work. They just want a magic bullet to fix their problem so they can go back to their heathenistic ways.
Without bills. Continue to be heathen, Continue running up a deficit, which is not loving your neighbors if you're raiding the storehouse and causing inflation.
Relief and remedy with no cause of action.
What do I want to eat? I'm hungry.
Where are you?
I am in upstate. I think I'm going to stop up here at this truck stop and go get me something to eat. Now, Beth, I'm glad you joined, by the way.
Yeah, thank you for telling me you guys were on. This is way ahead of me. I mean, I know basics of what you guys are talking about, and I love getting informed and then have new reading materials that I can go and look up and all of that kind of stuff. I do read the Bible. My grandfather was a pastor. My mother has 22 siblings, believe it or not, all raised in the church. My mom was raised in the church. I was raised in the church. I still read the Bible, but I always told my mom that there's some things in there that always stuck out to me that have different meanings, although I didn't understand them at the time. But as I got older, I realized some things were kind of a miss. And so I started reading it in a different way. So everything you guys talk about, it totally connects with me. So I'm very thankful that you guys put both of those together through all of this. So, that's amazing to me. But me personally, I have been looking into this for a really long time, and it always brings me back to the beginning of, okay, well, what the heck what's like the first step and yes, the first step is getting knowledge and understanding of what the heck is going on around you, following that narrow path instead of the wide path. And, I was talking to Pastor and a few other people about a lot of this stuff. And like I said, I'm still in that beginning stages where certain things have come to light that weren't previous. So I'm not quite caught up where you guys are right now with all the trust and the other stuff quite yet. But I do thank you guys for always just talking honestly, putting your hearts out there, giving people the information freely to anybody who wants to research it themselves, because that right there is what's going to bond us all together and raise up out of this. And I'm just thankful and grateful for that.
Well, I appreciate the input. The reason I called you out is a question you asked yesterday. And see, this is just my opinion. Do you have to do all of these things we're discussing about? I'm not sold on the idea that you have to. It's just one path that you can take. But I do believe you have to know the principles of how this stuff works. Okay? And how the system works, the principles of law. It's all right there in the Bible. Okay? Now, the reason I bring that up is you got some people that out there that don't do Luna. Stop it. Stop. That don't really care to do the secured party process and all that lovely stuff. And you don't have to. You've got other people that just want to go quietly into the night, be left alone, do their thing like David Roach. David Roach, he has no plates. He has shut up, dog. He has no plates on his car, no registration, no driver's license, and he travels in the state of Indiana as he sees fit. Has he fought for that? Absolutely, he has. Okay. Does he care about the secured party stuff? No, he don't. But learning how the system is set things up, each person has their own path. And right now, when it comes to mothers, especially giving birth, I'm of the opinion, based on what I've read so far out of the government's own words, we need to record our children, and we haven't done that. I told my wife, I said, we need to go to contact the hospital where my daughter was born and get the birth record and then record our daughter. And I made this discovery based on the regulation in New York dealing with birth registrations. And then I just followed the principles of law. My mother abandoned the infant. That means the hospital recorded the infant, which is the placenta. Well, who didn't get recorded? The baby. Mom never recorded the baby. Because both products of birth are to be recorded. And I was like, wow, that is huge. So right now, one of the things I'm working on, talk to my dad about it, because my dad does not take my word for nothing. I don't want him to. He says, I want to see what you're seeing. And then he'll go behind me and read it. And he says, that makes sense. I see where you're getting it from now. And I said, Dad, let's create our own birth records. And I said, and then you and Mom sign it, and then do an affidavit, take the affidavit, get it notarized, and you record your children. He said, okay, let's do it. Now you can show proof of a separation. Now you take that into what KW talks about, KRS 213.051, because I know that one by heart, and look at paragraph 4. It says if the child is identified and a birth certificate is found or obtained, it goes into a sealed record. What are we not doing? As parents, we're not recording our children and claiming our children. The only thing that's been recorded and claimed is the placenta, the infant.
Yeah, I didn't know that. I guess my head was wrapped around so far around trying to get the hospital or Vital Statistics to give me the records or whatever the case may be. But yeah, I actually heard of a guy that did that. He went and got his daughter, who was 2, he went and got her birth certificate. He went and recorded it in the newspaper and online on an online newspaper or something or another, and waited, went back, did it again, recorded it again, just the same way. But here's the kicker. When he went back the 3rd time and asked for another birth certificate, she couldn't find that child anywhere in the record. Like, she just wasn't there.
Yeah, well, let me, I'm going to go, let me find it right quick. John, cancel. John, let's do it that way. Whitfield. I'm going to post this in the group. Copy. This comes straight out of New York. Now, what it says is a live birth is defined as the complete expulsion or extraction from its mother of a product of conception, irrespective of the duration of pregnancy, which after such separation breathes or shows any other evidence of life, such as a beating of the heart, there's the baby, pulsation of the umbilical cord, there's the placenta, or definite movement of voluntary muscles, there's both. Whether or not the umbilical cord has been cut or the placenta is attached, that is the definition of what live birth is defined as. Then it says what? Each product of such a birth is considered live born. This is the first paragraph under the heading called birth registrations.
Well, yeah, that's why they call the placenta the afterbirth.
Yes, so since you abandoned the afterbirth, the placenta, the hospital can only record what it has in its possession. It has the placenta. So the birth record that the hospital said, ma'am, don't worry about it. You had such a hard delivery. We will record this for you, and you will get a certificate of birth in about 10 days. They record the placenta. You sign papers that you received your baby, like my mom did. You took the baby home, but you never recorded the baby. So you carry around a piece of paper, certificate of birth, thinking it's the baby, when it's actually the placenta, and then everybody's confused because why? They don't know how it fits together. They don't know what it is. They don't know the name. They don't understand all that.
So you're saying that what we should do with our parents and what we should do with our own kids if our parents are still alive is to actually do a recording. Now, would we record that with like the clerk, or will we do that in a newspaper?
You can record it the same place you record property, because where does the certificate of birth go? They send it to the county recorder, right?
Right.
You record your record in the same spot. Guess what? Yours supersedes theirs, because who's going to tell you you don't have firsthand knowledge of your children?
All right. So then what would that do? Would that give well, I know it would give our children back to us pretty much, but for ourselves individually, would that be our like claim to man or woman type thing and not property anymore?
I would say so, because you're not property now. You hold a social security. You hold a social security trust. The trust isn't you. It is the property of the state, but it's not you. So you are not the property. You were just volunteering to be the property.
Right. No, I get all that, and I don't mean it to come out that way, but I'm saying, to and not so many words, and no, my vocabulary is not as big as you guys, so I do apologize. But
no need to. You will get there.
But to pretty much say that, I am who I am, and I am not this property over here is what I'm saying.
Yes, because every man or woman has the right, when they are ready, they have the right to declare who they are. We're just not declaring it and doing it properly.
Okay, and what would that be the proper way to do it versus just walking in there and doing a name change? I mean, with the record, like you're talking about, would that be more of the proper way?
I would say it's one way. It's not the only way. It's one way. Now, your children, if they're still minors, then yeah, you have to do it for them as the mother. You have to do it a certain way. Okay. But when they become 18, if they decide to do a name change, yeah, that is one way. I know people that's done it. I know people that have a private name that is only used in the private, and they have that separation because the private name never goes into commerce.
That's actually not.
See, the principles of law are few and never changing. The methods are many and are fluid. What you're talking about are methods. In other words, do I do this way or do I do this way? Those are methods. If you know the principles, you can develop your own methods. See what I'm saying?
Yeah, no, I totally get what you're saying, and like when JW was talking earlier, I actually agree with both of you guys. I'm not in this to be paid or to get a bunch of money or anything like that. Yeah, I'd like to have some land. I can grow my own food and raise my own food or whatever and help the community that don't have food, open up a community garden and all that kind of stuff. Yeah, I would love to do all those things. But the most important part for me is to help other people if they want to be helped and to help my kids, because like I said, I've already had CPS called on me by family members. I've had them pounded down my doors because I have an autistic son and they feel like they can pretty much tell me what I need to do with him, even though they're nobodies. And I had my daughters taken away from me when I was 19. And so, as far as I'm concerned, only thing I want is just to have a family that doesn't have to worry about, having somebody bust down my door and taking my kids away from me.
Yeah, because right now you don't have everything in place to control them and sell the state. Okay, go ahead. Barbecue, Polish. Okay. So, but that's just, I mean, I know a lady in North Carolina, she did a full-fledged name change, and the Secretary of State's office in D.C. called her a sovereign. 100% on the phone, called her a sovereign and told her she'd have her passport in the morning, book and card. And good to their word, it was in her hand that next morning. Now, I know her personally. So, yeah, she declared who she was. She did it different. And she followed her path. She got her path. She did it her way. And guess what? She's not really cared to do much else after that. She just runs her little CBD shop, makes a living for her children, and she lives happily ever after.
So she did her name correction and sent it to the Secretary of State of the United States?
Oh, she didn't do a name correction. She did an actual legal name change. Full-fledged name change. She filed it in the court, got the order from the court. When she got the order from the court, she took it and all her explanatory documents and sent it with the DS-11 to the Secretary of State in D.C. And they called her on the phone when they got to her paperwork to process it and had that conversation with her that, oh, we can see you applied under this name at this time. Yep, I sure did, but I haven't applied under this name. No, you haven't. And she said, I have no contracts with the United States under this name. No, you don't. And then they tried to get her off her square. And they finally told her on the phone, yep, you're a sovereign. You will have your book and card in the morning. And she called me right after she got it. Told me the whole story. I said, I wish you'd have recorded that. She said I was scared to death and didn't think of it.
So they just asked her some questions to try and entrap her to being a United States citizen or to attach her to the old name?
No, they can't trap you into being something you're not. Okay, they're trying to get you to basically assume some liability so they don't have to respect your rights. That would probably be a better way of saying it. I mean, there was a judicial officer, a judge, that said everybody in federal court volunteered to be there, and a lot of people misunderstand what he meant by that.
Pastor.
Yeah.
It's Kim. Hey, I have some really cool stuff to share with you guys, but I'm at work right now, so we'll have to do this again, but we'll talk really soon because I really want to share with y'all just a silly little information, but I think it could be another piece of the pie to add to it, okay?
How you doing, Kim?
I'm great. Just studied my ass off, but anyway, I'm at work, and so I can't join in the conversation, so I just wanted to throw that out there real fast.
How long before you?
Probably another 45 minutes or so.
Okay.
But I'll be around tonight later, okay?
Okay.
Okay, I'll share.
Okay.
And I'll talk to you guys soon.
Okay.
Okay, bye.
All right, peace be with you, sister.
Thank you. Good energy and vibes.
Yeah.
Oh, I look forward to hearing that.
He had some accompanying documents that pretty much was like explaining the purpose of the name change and her position.
Well, now me, I mean, I'm not going to do a name change. I'm going to correct the record because see, you have a given name. I mean, back when I first started studying this stuff, I actually, you would see those people go into court on YouTube and you'd hear the stories of somebody going before a judge and they would call the name and they would immediately say my Christian name and they would start to spell it, right? And the judge would not accept that at all. Shut it down. All right. Well, I didn't know then as to why. You can't do that because that's not what he wants. He's wanting the trust. So if the trust isn't you and it has a different appellation, you need to record your spelling to show it's not the same person, not the same entity. Or you can do like Jazz did, Jazz Elise. She changed her name completely. 4.
So she changed it to a new name and not just corrected it to being from upper to
yeah. She totally completely changed her name. That's why she is now known as Jazz Elise.
So with that change, was that still a transfer, a title transfer, even though it was a new name?
Was it a title change?
Oh no, a transfer. So
Thank you. Have a good day.
She changed her name from that old name to that new name. Did all the assets and interest from that old name get transferred into the new name as well?
No, she hasn't done none of that. She hasn't even pursued it to even look into how to do it. She just wanted out of the system.
So that doesn't automatically like happen when you change your name?
Well, the point of her changing the name is she wanted out of the system. Because why? She understood all these contracts were under the birth estate. So what did she do? She separated herself from the birth estate by creating a whole new name. Go read the Fourth Amendment. What does the Fourth Amendment say? To be secure in your houses, your effects, something else. But it says persons. And every single word is plural. You can create as many persons in whatever way you decide to create them.
Okay, then I have another question, and I know people have probably already asked this, and like I said, I'm at the beginning of this.
Yep.
What if you're married, or you have been married and divorced and married again, or along those lines? So now, like me, I've had 3 different, we'll just say last names or family names, and do I have to go back to my maiden name in order to do the name change, or how does that work?
Every one of those marriages was under a marriage license, right?
Right.
Those are trusts. I've confirmed that in 4 states. When you paid that marriage license fee, a good portion of the fee went to a trust fund. Okay? It is not a contract between you, your spouse, and God.
Right.
It is a contract between you, your spouse, and the state.
Right.
Now, if the birth certificate is a registered organization, which it is, right?
Right.
A marriage license is a corporate merger.
Right. That's why it goes back to vital statistics. My marriage license says it right on there. It says vital statistics.
So guess what? You can declare yourself who you want to be anytime you want, in any way you want.
Right.
As long as you're not trying to commit fraud, yeah, you have that right. Eon on YouTube, Eon, he just made the court start calling him Eon. That's why his name is Eon. He didn't do no legal process. He didn't file no papers. He just told the court to call me Eon, and guess what they do? He's got 37 different cases I found on Westlaw where his name shows up as Eon.
Okay, so are you? So we don't have to like be divorced or anything like that in order for us to finish this process, or like our own process. I understand the principles of what you're saying and things, and everybody can take the road that is right for them, depending on their circumstances or what have you. But I just had heard that it would be better to divorce so that a way I'm not in his estate or vice versa or whatever. That's what I was asking about.
Well, I mean, if you want to separate yourself from that estate, yeah, you can.
Because, I mean, and I talked to him about it too, and he agrees, we would rather be, even if we have to divorce and then actually do the right thing between us both and God and be married under God versus the state. I mean, that's what we would want to do, and that's how we would want to share that with our kids. You know what I'm saying?
Yes, I understand. Yeah, you can do that. All you're doing on the divorce is separating the 2 corporations. And so you could do that very easily, and then do a contract of matrimony at whenever you want. I do know there are pastors, not many, that understand this and will marry you under a contract of matrimony. There's one in Tennessee. My dad and my stepmother got married that way under a contract of matrimony. See, all this is really, and for me, it's learning how to do things in the private, where your private rights are at.
That I agree with that. And that's where we want to be. We want to be in the private. Now, I guess my next question is operating in the private. I know that somewhere along the line, we're still going to have to do things in the public per se.
Yeah.
We just have to be able to do it in a way that we're not recontracting and bringing ourselves back into that whole situation.
You don't even have to get a divorce. Leave the married corporate entities as your public vessels and correct your information on the private side as your private names and do a contract of matrimony. Now, guess what? Now, if the state tries to interfere with your private side, you've got your documents in order to show the separation to where they can't touch you and your children. They can only go after the estate.
That was the answer I was looking for. Thank you for that.
Yeah, because even if you dissolve everything and you rescind every possible contract you think you have, you're still going to have something to operate in commerce, be it a trust.
I think we lost you.
No, I had a phone call. I guess JW didn't like what I was saying and probably left. I just read what he said. But no, even if you create your whole private name, persona, the whole 9 yards, you still got to have something to operate in trust. I mean, not trust, in commerce. It could be a DBA, it could be an LLC, it could be an S Corp, it can be a trust, it can be whatever you want it to be. But you have to have that separation. And right now, the problem is there's no separation.
Right, which is what I'm trying to do right now.
And it is why, based on what JW said, even though he does understand a lot of it, the hardest thing for people to understand is the stuff that revolve around the name. See, I've done the secured party process. Is there a place for it? Yes. Does it have to be done? No. Do you have to do all these templates and all these things these gurus throw out there? No, you really don't. You can, but that depends on the path you want to take. I gave you one example, David Roach. He ain't done none of those templates, none of those things. Don't really care. Now, did he have to fight for it? Yes. Did he have to go to court quite a few times? Yes. And he's won pretty much all but 2 cases. And the first 2 cases he lost. Why did he lose? He was new at it. But he's also like me. I'm not afraid to go to court. I mean, you go look at Brian Parker. Brian Parker learned a lot of this? Has he done a secured party process? No. Did he do the resignation as registered agent? Yeah. He has private plates on his vehicle in Florida, no registration, no driver's license, to my knowledge, if I remember correctly. My dad has private plates, no registration on his vehicle. He still has his driver's license. He's a businessman. He says, why? I said, why do you have your driver's license? He said, because one day I might be in commerce. I own a business. And has he done the secured party process? Yeah, my dad has. It's more about learning the principles than it is the method that you do. Because if you learn the principles, you can develop your own method and call it whatever you want. And almost every statute, code, rule, regulation, or law, whatever you want to call it, is based on a principle. I mean, people don't like it when I say it, but 99.9% of all the laws that are passed in the country are constitutional. But people don't like that. I said, because they don't understand the Constitution. I mean, look, a lot of the laws are not even laws. They're resolutions that were passed. Guess what? Article 1, Section 10. The government has the right to contract unlimited just like you do. So guess what they do? They put things out there that are based on contracts. Just the question is do you know that? You know what I'm saying? That's the thing. People, they've got to learn the principles. They got to learn how this stuff applies. And yeah, JW, a lot of his principles, he is rock solid on those. He's right. He takes it back to the Bible. But do you have to do some of these things? No.
Yeah, no, I've actually seen some people, and the proof that they show it too is, they've used that whole coupon method or whatever for their bills and stuff like that, and they've not changed anything. They've not done anything. I guess they found how the principles, like you said, the principles work in their favor when it comes to something like that, and they use it without doing anything that everybody else is doing. So,
But hey, I'm gonna take a little break for a half hour. She said she's gonna come on here in about 30 more minutes, and I'm gonna eat my food. So if I leave, I don't know if everybody else will leave or not, because I don't think there's any admins in here since JW left. But Kim said she wants to come back on because she's got something to share. So I'm going to eat my food and take a little break.
All right, man. You take your break, and now we'll talk to you when you come back on.
Okay.
Enjoy your meal.
Talk to you later.